Okay, everybody, I'd like to invite you to have a seat, and we're going to get started with our next presenter. Couple more housekeeping matters on my end. There might be some things that you want that, like in terms of motions or requests or something that's part of the presentations that you're hearing. We will absolutely, at the Public Defender's Office, we'll do everything we can to get you what you want if you let us know what it is. I'm in the courthouse all the time. As simple as give me your card with your email on it and say, hey, that person spoke on Voir or whatever it might be, and I'm happy to try to get you that request that was mentioned or whatever it is you want, because sharing the information is the most valuable part of what we're doing with these CLEs. I mean, we can talk about it, but if you get a form or something out of it, that's even better. So let me know if you see me. We're also located at 1301 Franklin, which is the old jail. That's the place that they found for the Public Defender's Office. It's not jail cells, but it's on the first floor. So if you pop by between 8 and 5 when our admin's there, or at least someone to answer the door, because it has like this little code key, that's great. Do not come between 5 p.m. and 8 a.m. because I heard the rats take over the place, so you don't want to mess with those guys. But yeah, stop by and say, hey, I was at the CLE. I would like a copy of this. The response will get to you via email or whatever medium you want. So I just want you to know that we're speaking, but if you want something, you may have it, because there might be some kind of something missing from your own personal emotions bank that we can help you supplement. I noticed also the Astros play tomorrow at 1 o'clock. If you didn't realize that, I thought that'd be a good thing for you to know, because that's going to create all kinds of parking situations, not just for this CLE, but of course for your journey to your 1 o'clock p.m. dockets tomorrow. So I just wanted to mention that just in case you didn't know what was going on. Great. So Jordan Lewis is here. He's going to talk to us about Voir. I'm intrigued. Scary is good. We're going to find out all about that. Please welcome Jordan Lewis.
Howdy. My name is Jordan Lewis. I'm a criminal defense lawyer here in Houston. I did mock trial all through law school. It was hands down the most helpful thing that I did while I was in law school, because I got out of school knowing how to handle myself in a courtroom. But the one thing that we never touched on in mock trial is Voir. And so for the first handful of cases, Voir scared the crap out of me. And how many of you still kind of feel like you wish you knew better how to handle yourself? Okay. What I finally learned was, if you can have a conversation with people in a bar, you can do Voir and do it well. Now, one of the hardest things about Voir is the difference between planning and scripting. You need to know where you're going, and you need to know where you want the jury to go, but if you write a script, it's all going to fall apart when somebody throws the first punch. One of my favorite quotes ever is from Mike Tyson. Everybody has a plan until they get punched in the face. I've heard somebody say that in war, no battle plan survives the first encounter. Things change. You've got to have an idea of where you're going to go, but if your plan is predicated on everything playing out the way you need it to, you're going to get about 2 questions in and realize that you're screwed. Justice Ginsburg gave some advice to people who were preparing an oral argument for the Supreme Court. Basically what she says is, don't put yourself on a script, because you're never going to get to use it. Lay out your first sentence, know word for word what your first sentence is going to be, and then from there understand that argument is a conversation between the lawyer and the bench. Voir is a conversation between the lawyer and the jurors. So you need to be prepared, but you also need to be flexible, because things will not play out the way that you want them to. In Voir, you've got 2 goals. Your number 1 goal and the most important goal is to learn everything you can about the people that you're dealing with, so you can figure out who needs to go home, who can stay, and who you're willing to accept if it comes to that. You've also got to try to earn the jury's trust, because at the end of the day, we start at a trust deficit. Our client is accused of a crime. The judge is very often not going to be terribly friendly to us, and you're going to have prosecutors parading a bunch of dudes in uniform through the courtroom to point at your guy and talk about how terrible they are. The only way that we overcome that is if the jury trusts us at least as much as they trust the prosecutor to not lead them astray. How many of y'all are feeling about like this right now? I know I came in after lunch. How many of you have ever gotten about halfway through your voir dire and you feel like this is what you're dealing with? Okay, I've had it happen too. What I find is that typically what's going on there is that you're lecturing these people. After the judge lectured them and after the prosecutor lectured them, and what they don't need right now is another 45 minutes of some puffed up dude in a suit or some puffed up lady in a suit. Voir dire needs to be interactive to be helpful, but the problem is that normal people hate public speaking. They don't like to speak in front of a group. Psychologists have done lots of studies on what people are truly afraid of. What do you rank as your top 3 fears? Public speaking consistently ranks higher than snakes, consistently ranks higher than bugs, consistently ranks higher than heights, falling, dying. The only thing that consistently ranks higher than public speaking is the fear of a fear of losing your own child. Right behind that is getting up in front of a group of people and talking. And if you're going to do voir dire right, you need these people to be willing to talk in front of a group of people that they've known for a couple hours at most. So your job as a lawyer doing a voir dire is to make the jury feel like this is a safe place for you to talk. So how do we do that? The first thing you've got to do is listen to them. If someone is talking to you, listen to them. Dale Carnegie and I will give credit to Mark Bennett for getting me to read a book that my mom had been trying to get me to read for a couple of decades now. How to Win Friends and Influence People. There's a lot of good stuff in there. One of the things that Dale Carnegie says is to be interesting, all right, let me take a step back. You want to be interesting. You want, to the greatest extent possible, the jurors hanging on your every word. You want them to want to know what you're going to do next, what you're going to say next, and ultimately, you want them to want to know what you want them to do, which I know is a convoluted way of saying you want them ready at the end of the case when you're giving your closing argument, just waiting for you to tell them, okay, what do I need to do? The first way to start getting there is when people are talking to you, be interested. Body language communicates so much, and we don't really even think about it. How many of us, when we get up to give a voir dire, get up to give an argument, kind of feel ourselves puffing up? The shoulders go back, maybe the voice comes down about a half an octave. All right, we'll get to that in a minute. Leave that guy at home, he's not helping you. A relaxed but attentive body language is what you're going for. If you normally stand like this, then stand like this when the juror's talking to you. If you're all puffed up and you're up above them and looking down at them, that's going to shut them down. You may get a sentence or two out of them, and then they're going to shut down. It also communicates to the other 30 to 60 people in the room that you're not likely to care anymore about what they are saying than you did about what this guy is saying, and so you're not going to get anything out of it. Part of what you want to do is make yourself a part of the group that has formed in the 2.5 hours that these people have been sitting in the jury assembly area, and then waiting in a hallway to be called into the room, and then in some cases called into the room just to be told that you're going to be another couple hours and then sent back out into the room. That group starts to come together, they start to form some cliques, but at the beginning of the voir dire, you are absolutely, positively not one of them. And you need to understand that, because that places some limits on what you can say and do to juror number 5 without every other juror in the room bristling in a desire to protect that person from this asshole that's jumping on them from the front of the room. One of the ways that you can start to ingratiate yourself to the group is to use inclusive language. If you want to ask them, how many of us feel like drinking and driving is a pretty simple thing. You just don't drink and drive. And you include yourself in the group. How many of us would agree that it's really not appropriate to try to force a defendant to prove his innocence? When jurors start giving you things, all right, how many of us agree with what that guy just said? By using the inclusive language, you can do a couple of things. Number one, you begin to make yourself a part of their group, but you also message to them that, hey, if you're feeling this way, you're not the only person in the room, it's safe for you to raise your hand. There are other people. You assume in the form of your question that there are several people in the room that are going to feel this way, and so nobody feels like the pioneer if their hand goes up first. Let me ask you all this. How many of you have ever thought you had a pretty good idea, but you weren't willing to put it out there because you didn't know how well it would be received? If there's anybody in the room that's never felt that, I would say I don't believe you. You're dealing with group dynamics, and a huge part of an effective voir dire is understanding the group dynamics and, quite frankly, working them. Normal people hate lawyers. Period. They hate lawyers, but they like people. Or put another way, and more importantly to voir dire, normal people don't trust lawyers. We have a societal distrust of lawyers that goes back at least to Shakespeare. Shakespeare said we should kill all the lawyers. I'm sorry? Well, I don't think they were pillars of the community. Well, they were pillars of the community, but they... Sorry? Okay. And that's probably true. How many, well, let me ask you this. How many of you have gotten a funny look when you told someone for the first time that you're a criminal defense lawyer? Yeah, absolutely, right? How often do you think that prosecutors get that same look when they tell people, I'm a prosecutor? Never. So we're dealing with a credibility deficit. If you walk in there and you talk to these people like a lawyer, if you act like a lawyer, if you behave like a lawyer, you're never going to get into the group and you're never going to earn their trust, and they're going to view you and everything you say and every piece of evidence that you present with the same skepticism that most people have learned to view lawyers with. But they like normal people. Your goal by the end of voir dire is to be a normal person who also happens to be a criminal defense lawyer. If you can get there, then you'll be all right. So how do you do that? Well, you've got to be happy and relaxed. And the way you get to be happy and relaxed is to be yourself. And the easiest way to feel comfortable being yourself is to be happy and relaxed. It's a cycle. I don't remember where I got this. I did not create this graphic, but I think it states it pretty well. If you get up there with the feeling that you're about to talk to this panel of jurors who are going to decide your client's fate, you're going to have trouble getting into a relaxed place where you can have a conversation with them. Just get up there and treat them like you would treat any group of people that you were talking to about something completely different. And a lot of times it's helpful to break the ice with something that has absolutely nothing to do with your case. Like I said a few minutes ago, that the big impressive lawyer that lives inside of all of us, that our mock trial and moot court coaches tried to get out of us and that law school convinces us is the right way to go, does nothing but hurt you. People don't like that guy. That's why you only bring him out in the courtroom. You don't bring him out in the bar. You've learned that people think that guy's a douchebag. Just be a person. If you are able to have a conversation with normal people, you can do voir dire. You've just got to get over yourself and do it. My time's going a lot faster than this went in my head. So one of the things you have to do with the jury is to build their trust. And there are a handful of ways that you can build trust with a jury, but the first one is be honest. And not just honest, but be brutally honest. So when I was in law school, we had a TV judge who came and talked to us, and his spiel that week was on voir dire. And his advice to us was, don't just be honest with the jury, you got to be brutally honest. And somebody said, well, what do you mean by that? And he said, I'm glad you asked. Being honest is telling your wife that you had an affair. Being brutally honest is telling her that you learned a couple of things that you might like her to try because it was really, really good. So, another way that we talk about being brutally honest in cases is you got to hug the turd. You wouldn't likely be going to trial if your case was a slam dunk, right? Those cases get dismissed. Somewhere in your set of facts, there are going to be some bad facts that you have to deal with, right? By the time the jury is in the room, have you figured out how it is that you're going to go about dealing with those bad facts? Yay? Nay? If you haven't, you're in a lot of trouble, and so is your client. If you have, now is the time to begin addressing those things. And tell them straight out, folks, you're going to see some evidence in this case that, under normal circumstances, might make you think that this guy is guilty as sin. But, and that's where you get into, and you've got to dance on a razor's edge here because you're not supposed to get into the straight facts of the case. If you have a line of thinking that you need the jury on to go where you're going, now is the time to start planting those seeds. Even better is if you can begin talking about a hypothetical scenario and get the jury to give you what the defenses would be in a scenario like that. So if you've got a fraud case and your client clearly got thousands and thousands of dollars that he was not entitled to get, what are some circumstances where your client might not be guilty of fraud? Okay? Let's say it's insurance fraud, or I had a workers' comp fraud case a couple of months ago. My client